In the shadow of Lichfield's three-spired cathedral, a laborer delving in the muck at the bottom of a pond came upon 2 gold rings. "Give them to us," said his employer. "It's our pond. The precious rings are ours." "But I found them," countered the laborer. "They should be mine." Whose rings were they? The Queen's Bench had to decide in South Staffordshire Water Company versus Sharman. The city of Lichfield transferred title of Minster Pool to the South Staffordshire Water Company in 1872. In 1895, the company hired Sharman and several other workers to clean the pond. The workers unearthed multiple items of interest, including the 2 gold rings that Sharman found in the mud. The company demanded that Sharman give it the rings, but he refused, and instead gave them to the police. After the police failed to find the rings' owners, they returned the rings to Sharman. The water company sued Sharman in the County Court of Staffordshire, seeking to recover the 2 rings. It argued that if an article is found on private property, it belongs to the landowner, even if he's unaware of the item's existence. Sharman countered that the mere ownership of land doesn't create presumptive possession of all things found on it. Citing the legal scholar Blackstone, Sharman argued that allowing treasures to be scattered on property was such dereliction that a found object should become the property of the first person to find it. The court considered the case Bridges versus Hawksworth, in which someone dropped a handful of cash in a shop. A customer found the money and gave it to the shopkeeper. The owner of the cash was never found. The court awarded the money to the customer who picked it up, on the ground that the notes were dropped in a public place and had never been in the shopkeeper's custody. Based on this precedent, the court held that a finder has good title against anyone except the real owner of the found item, and awarded the rings to Sharman. The water company appealed to the Court of the Queen's Bench.